Hello and welcome to The Print. My name is Apoorva Mandhani and I bring you this instant analysis on the Supreme Court granting bail to BRS leader K Kavitha in the Delhi liquor policy case. The Supreme Court on Tuesday granted her bail in the CBI and ED cases against her. The order was passed by a bench comprising Justices B.R. Gavai and K.V. Vishwanathan, overturning a Delhi High Court judgment which was passed in July that had refused to grant her bail. Now, Kavitha is the third major political leader to be released on bail in this case after Supreme Court granted bail to Aam Aadmi Party leaders Sanjay Singh and Manish Sisodia. And it was the Supreme Court's order in Sisodia's case as well as an exception under the money laundering law or the PMLA, the Prevention of Money Laundering Act, that came to Kavitha's rescue. Now, arguing for her before the Supreme Court on Kavitha's behalf, senior advocate Mukul Rohatgi relied on the Supreme Court granting bail to Sisodia, submitting that both the cases have the same facts. In Sisodia's case, the court had emphasized on speedy trial being a fundamental right under Article 21 of the Constitution and opined that the long incarceration and the fact that the trial has not even begun yet means that Sisodia has been deprived of his right to speedy trial. So, Rohatgi now pointed out that in both the cases there are 493 witnesses to be examined and about 50,000 pages of documents. Apart from this, Rohatgi also submitted that she is entitled to special treatment under Section 45 of the Prevention of Money Laundering Act 2002. Now, let me tell you a little bit about this special treatment that he was talking about. Section 45 pertains to bail under PMLA. It lays down the strict twin conditions of bail under the law, which makes getting bail under this money laundering law extremely difficult. It says that bail can be granted to an accused in a money laundering case only if two conditions are satisfied. There should be prima facie satisfaction that the accused has not committed the offence and that he is not likely to commit any offence while on bail. So, it essentially reverses the burden on the accused to prove that he is prima facie not guilty of the offence. However, a proviso of Section 45 says that a person who is less than 16 years old or a woman or a person who is sick or somebody who has been accused of money laundering a sum of less than 1 crore rupees may be granted bail. So, essentially this exception permits certain categories of accused, including women, to be released on bail without the application of the twin conditions, the stringent twin conditions under Section 45, making bail for these categories of people a little easier. Now, the Delhi High Court in its 1st July judgment had denied the application of this exception for women to Kavitha's case. In denying her bail, Justice Swarnakanta Sharma of High Court had observed that Kavitha is a well-educated and accomplished woman who has been an MP, a member of a legislative council as well. It had therefore said that Kavitha cannot be equated to a vulnerable woman. Essentially, the High Court felt that it was vulnerable women who may have been misused to commit an offence who should be granted an exception under Section 45. So, it felt that this exception was only applicable and incorporated in the law for vulnerable women who may have been misused to commit an offence, and it now said that Kavitha doesn't fall under that category of vulnerable women. Now, the Supreme Court, while analysing this exception as well as the High Court judgment, accepted that no woman accused would automatically be entitled to the benefit of the exception, but it said that when a law specifically provides a special category for a certain special treatment for a certain category of accused, the court has to give specific reasons if such benefit is denied. So, referring to the Delhi High Court order, the Supreme Court now said that day in and day out it is argued by prosecution that merely because an accused has a special status or if they are MPs or MLAs or ministers, they should not be given a special treatment and should be treated equally as any other accused. The Supreme Court now opined that the Delhi High Court judge erroneously observed that the proviso to Section 45 is applicable only to a vulnerable woman. It therefore found that the High Court judge misdirected herself, this is what the Supreme Court said, while denying the benefit of the proviso to Section 45(1) of the PMLA to Kavitha. The court also noted that Kavitha's custody is not necessary for investigation. It noted that she has been behind bars for the last 5 months, and it cited Sisodia's case to reiterate that there are about 493 witnesses and 50,000 pages of documents to be examined, saying that the likelihood of the trial being concluded in the near future is impossible, and this is why the Supreme Court granted bail to Kavitha on Tuesday.